Wow. First, I'd like to thank Dana Quick, who is co-presenting today. And I'd like to thank Carrie Ramirez, our operations manager, who does all of the behind-the-scenes things in order to allow us to do these webinars. My name is Carl Habekost. I'm an attorney at Bugby & Conkle, and we are going to get moving on sexual harassment in the workplace. What a hot topic. Wow, seems like every time you turn on the news, there's something about sexual harassment. Just today, from a legal news feed that we get in the office, 4 articles involve sexual harassment and sexual assault. Roger Ailes, a famous news anchor, is named in a lawsuit against Fox News for watching female news anchors undress while they would try on new outfits for the next season. A Virginia firefighter sued the Fairfax Fire Department for sexual harassment. She had been a long-term firefighter, very successful, went to a news station and was sued for sexual harassment from her new supervisor. A renowned professor of philosophy at the University of California at Berkeley was named in a lawsuit against the University of California because he apparently had been engaging in sexual harassment against a student female researcher that also involved watching porn while they were doing research on philosophical matters. Quite an interesting combination. A yacht worker won a $70 million sexual assault verdict. So for those of you who are involved in workplace safety, this individual had been harassed by a coworker sexually. The company was aware of it, and he came back to the yacht drunk one night against company rules. A couple of the safety mechanisms were not working. She was severely assaulted, and the company now is liable for a $70 million verdict. And that's just today. That doesn't count Harvey Weinstein, Kevin Spacey, even Stephen Wynn, the owner of hotels and casinos. It goes on and on. This is an issue that's not going to go away. So we'll at least have one webinar this year on sexual harassment and ways that you can deal with it. We probably will have another one later in the calendar year. Well, here's what we're going to talk about today. We're going to kind of break this hot topic down into 3 main subject areas. First, we'll actually discuss what is sexual harassment. We may think we know what it is, but it's always good to get a definition of it. A good working definition. We'll go through some examples of it, talk about some court cases, and then move on to ways that a company might be able to prevent sexual harassment. That involves training in establishing clear reporting procedures. And finally, what do you do, God forbid, if you actually have a sexual harassment complaint? How do you investigate it, and what corrective action would you take? Well, here is, I guess, the point where it all began. 54 years ago now, the Civil Rights Act in 1964. Title VII of the Civil Rights Act specifically indicated or indicates that harassment discrimination based on sex is illegal. So that's why we're talking about it. It's flat out illegal. This particular law was amended in 1991 to allow for damages and trial by juries. So it's become an economic factor. The administrative agency, the federal agency, is the Equal Opportunity Employment Commission. That agency enforces Title VII provisions. So what I want to emphasize again is that despite the high-profile publicity, despite the fact this law has been on the books for now 54 years, It still happens. It's not going away. Companies need to be proactive and deal with it. What is sexual harassment? The EEOC has a very wordy definition of sexual harassment. It's on your screen right now. The key words are unwelcome sexual advances. Now, we'll talk about the most obvious sexual harassment. That is, requests for sexual favors. But there are also some subtle forms of sexual harassment that you may not be aware of. This is the working definition for the administrative agency that handles these matters. Sexual harassment can be explicit or implicit, but it must affect an individual's employment. It must unreasonably interfere with work performance, or it can create a hostile or offensive work environment. So that's basically words. Why don't we see if we can just talk about some scenarios that might give you a better picture of what we mean by sexual harassment. This slide, we say recognize workplace sexual harassment. So we're going to give some examples of sexual harassment, but then we also want to talk a little bit about how do you recognize it. We're going to try to increase your sensitivity to this area. There are unwanted sexual advances that can take different forms. It can even be something along the lines of somebody putting their hands on you and saying, you know, excuse me, can I take a look at that paper? But the individual might find it offensive. So how do you know that that individual might find it offensive? Perhaps they cringe when you're touched. Visual conduct, maybe the way an individual looks at a worker. Maybe a supervisor looks at an employee in a way that makes that person uncomfortable. How do you know? Maybe the employee tends to drop their eyes when the supervisor comes by and oogles at them. Verbal conduct. Some examples. Jokes. Maybe the supervisor wants to have somebody feel comfortable, so they tell a joke, perhaps a little off-color. You can tell how the individual reacts by not laughing. Maybe the individual just kind of rolls their eyes, the employee rolls their eyes, and you can tell they're going, gee, Merry Christmas, this is out of line. You know, President George Bush, former President George Bush, who's now 92, 93, 94, was noted in the news as telling an off-color joke. Standard procedure for him, apparently he just found that may make somebody feel a little more comfortable, but it was clearly inappropriate, and some females now are coming forward and indicating that. It could be something, verbal conduct, as simple as, I like your outfit today. And the employee may not appreciate that. Written conduct that can involve emails, jokes in the emails that are inappropriate. Physical conduct. Think of some scenarios that you may have witnessed over the years that involve physical conduct of a sexual nature. Not only touching, maybe a male employee blocks the hallway, so a female employee has to try to skirt around the male employee to get down the hall. And in doing so, they touch. That could, over time, develop a hostile work environment. Other types of conduct would be basically things like perhaps an individual watches pornography in the office and sounds emanate from the office that are obviously sexual in nature. Over a period of time, that can create a hostile work environment. Maybe an employee puts pictures on their cubicle that would involve men modeling underwear, and maybe a man feels uncomfortable about that. So there's some other ways that sexual harassment can develop in the workplace. Well, who is protected from unlawful sexual harassment? Obviously, we think of employees. Your employees are entitled to a workplace that's free of harassment, specifically sexual harassment is what we're talking about today. You might be surprised that even job applicants are protected from sexual harassment. How about independent contractors? You think they are protected from sexual harassment? I got a good one for you. What about third parties who come in and actually work in your building? What about your computer people who come in and fix your computers? Are they protected from sexual harassment? So we'll answer some of those questions as we move along today. This is food for thought. We've covered who might be protected from unlawful sexual harassment. Well, who could be the harassers? Supervisors are the most obvious choice. Supervisors clearly have liability for sexual harassment, and most often supervisors are the agent of sexual harassment that we see in lawsuits. Other employees, of course, coworker sexual harassment is very common as well. Former employees can be coming in, causing problems in the workplace, including sexual harassment, so they can be a potential harasser that would cause liability for the employers. We discussed vendors, but how about this one? What about customers? What if you have a customer that comes in, or a customer who comes in, and likes the receptionist in the office? Perhaps that customer is 50% of the gross income for your company. All right, maybe that's a little high. How about 20%? How about 25% of the gross income for your company? And the receptionist has reported, pursuant to this very clear and documented reporting system that you have outlined in your handbook, which Dana will talk about here in a little bit, that she's uncomfortable with this customer coming in, and the customer is harassing her.
Or him.
Or him. What do? How do you handle that? Do you directly confront this person? Maybe you can come up with some ideas that would limit his access to the facility, to the workplace. Or maybe you ask that your customer schedule the time that they come into the workplace so that you can manage the environment a little bit better. So we've actually seen cases where a big customer comes in and wants to have a date with the receptionist and makes it very uncomfortable. So those are some ideas and concepts that you need to think about, and hopefully we'll flesh out those topics as we move along today. Well, what is your liability, and how does an employer incur liability in this area? Well, you know, employers can be liable for conduct of supervisors and managers. That's obvious. That is a picture of, I believe, is that Harvey Weinstein?
Yes.
You know how bad Harvey Weinstein was? He got fired from his own company. Now that's pretty bad.
So you're saying that owners are not immune to
Owners are not
liability?
immune, no. But it's not just supervisors and managers, as we talked. Employers can be liable for sexual harassment by coworkers, vendors, customers, or visitors. If the employer knew about the conduct, let's take a second here and analyze those words. What does that mean, if the employer knew about the conduct? Does there have to be an actual report of sexual harassment before the employer can be held to the standard of knowing of the conduct? What do you think, Dana?
I would say no. There does not have to be a physical, tangible report.
Exactly. It could be just common knowledge. It could be cultural knowledge. So though that knowledge is imputed to the company, it becomes an evidentiary issue. That's why you have to have training on these issues. Obviously, if you know about it, you need to take immediate and appropriate corrective action, because companies that fail to take prompt action and sufficient corrective action are the companies that get into big problems. There are essentially two broad categories in the sexual harassment world. One, and the most obvious, is what we call quid pro quo. These Latin words keep attorneys in business. We feel pretty cool. We can use Latin. Quid pro quo means something for something. We'll talk about that in a second, but that's the most obvious. The second category is hostile work environment. We've touched upon that, and that is not quite as obvious, and it can be confusing. That's where we need skilled, sophisticated human resource individuals to handle those situations, to make sure that your workplace does not become hostile. Well, what do we mean by quid pro quo in a little more detail? As I said, that means something for something. It's the most obvious form of sexual harassment. It can be explicit. That means it's really obvious. Really, really obvious. Or it could be implicit. And by the way, it only takes one time, one instance of quid pro quo sexual harassment to constitute enough, anyway, for a potential lawsuit. You know, quid pro quo describes a situation where an employee is confronted with sexual demands in return for something that will benefit that employee, such as a raise, a promotion, or even just keeping their job. And we'll have a case that we talk about that. That's pretty explicit. For example, oh, Dana, if you spend Friday night with me, we'll make you a partner. That's explicit.
Depends on what we're doing, Carl.
We're going to go down water slides all night. Or implicit, if I say something along the lines of, hey, you know, Dana, around here, people who cooperate, they get better performance reviews and they make some more money. Wink, wink. So that's what we mean by implicit. So that's quid pro quo, quickly. I guess you would call seminal case in this area was addressed by the Supreme Court of the United States. And here are the basic facts. A manager said to the employee, just as I indicated, hey, if you want to continue your employment, you're going to basically have to have sex with me. So the employee engaged in a sexual relationship with her supervisor. She met him in a hotel for more than a year. After a while, she just said, I can't do this anymore, and she ended the relationship. Shortly after ending the relationship, her performance evaluations went down, and she was eventually fired. Not surprisingly, she filed lawsuit for sexual harassment, and the company defended the lawsuit all the way to the United States Supreme Court, arguing that it didn't know anything about this affair. It had never been informed of this affair. And oh, by the way, nobody forced her to go to the hotel and have sex with her supervisor. Well, the United States Supreme Court said, no, this is sexual harassment, and the company is liable for damages. The company should have been aware of the manager's conduct. The manager is an agent of the company, has managerial authority, and his knowledge is imputed to the company. And by the way, the most important thing they said was, you know, that argument about the fact that she willingly engaged in this affair with her supervisor is not persuasive. It was made clear that her job depended on her cooperation, and the best evidence of that was she was fired after she ended the affair. So that is an example of quid pro quo sexual harassment. Anything else you want to add on that, Dana?
No.
Nope. Okay. Well, what do we mean by hostile work environment? It's not necessarily hostile in the sense of throwing things at people. It's hostile in an emotional and psychological aspect. A sexually hostile work environment occurs when unwelcome conduct of a sexual nature occurs, and that's a subjective standard. That is not what the harasser or the offender meant. It's what the victim perceived. So that's the subjective part of it. But in order to prove that, it becomes an evidentiary issue. And that offensive conduct has to be objectively severe and pervasive enough to result in an environment that's abusive and hostile. And that's why a few minutes ago I said quid pro quo harassment can just be one incident. But hostile work environment of a sexual nature is more chronic. It takes more instances. How about some forms to see if we can raise our consciousness level here and come up with some examples of a hostile work environment? Unwelcome physical touching. It might even be totally innocent. I put my hand on Carrie's shoulder to talk to her. But I should be astute enough and sensitive enough to know that that bothers her, because she cringes and begins to pull away when I do that on a regular basis. And you notify me that you don't like that, don't do it anymore. But if I continue to do it, you notify management, that becomes a hostile work environment. The eyes, you know, the leering, the oogling, what's known as elevator eyes, that continues over a period of time. That creates a hostile work environment. It's just uncomfortable for people to work in that environment. As I indicated, sexually suggestive cartoons, pictures, posters, can even come out in some emails, some inappropriate pictures and emails. If that occurs over time on a regular basis, that can be sexually hostile. Catcalls or whistling, we've seen that before. Sexual comments about a person's body. I have to just bring this to your attention. If any of you have seen Anchorman, and the name of Tits McGee being used, that's an example of sexual comments about a person's body. And, you know, we can laugh and giggle a little bit, but, you know, that goes on. I mean, people will talk about the well-endowed woman as she walks down the hallway. So, sexually degrading words to describe a person, there are all kinds of examples. I don't really care to move on. You can see some of them up there on the screen. How about blocking or impeding someone's movement, if that continues on a regular basis. One example we just talked about was sort of blocking the hallway or making it difficult for an individual, male or female, to pass by without touching the other person. You know, we were talking about this the other day, Matt Lauer, and he would lock the door. That pretty much impedes somebody's ability to move and leave. Anything else?
Cornering somebody in an enclosed area.
Like in an office or
a
big
tool room. I've heard tool rooms are notorious for being cornered.
Fortunately, we don't have a tool room here.
We do not.
Yeah. We have a computer room, though. So,
but even if it's an open area, I think, like, if you're coming from one room into another and somebody's blocking the way, that impediment, whether or not you're in an enclosed area, could be a form of hostile work environment.
Sure. Now, how many instances of that do you think would begin to constitute a hostile work environment?
Just one.
Just one? So it kind of depends on the severity of it.
Yes.
Right. Sending emails with sexual innuendos, or, as I indicated, watching porn or erotic sounds coming out of an office on a regular basis. Those are all just examples. I mean, there are others, but we kind of wanted to raise your awareness so you can recognize forms of hostile work environments. An example of a case, sexual harassment, where the individual, and I wanted to bring this up because this individual lost no pay, and the individual admitted that she was not specifically, directly sexually harassed. Okay. A female employee objected to explicit photos in magazines that were left in plain view. She advised her supervisor and manager that, you know, this is offensive to me. I don't like this. And she did it on 2 occasions. The company took no action. So she filed a lawsuit against the company claiming the pornographic material created a hostile work environment. The jury awarded her $875,000 in damages. So the courts have ruled that posting explicit pornography obviously is over the line, but even less explicit sexually suggested photographs can be just as offensive. Keep that in mind. It's important that you understand that there is a form of sexual harassment that we call gender stereotyping. Negative gender-specific comments, for example, that's a man's job, a woman could never handle that. Women are just too sensitive to handle high-pressure jobs. My favorite men are pigs and cannot be trusted. These are all negative gender-specific comments that can lead to claims of sexual harassment due to a hostile work environment. To further tag on the gender thought process, as Dana and I discussed several minutes ago, sexual harassment is not gender specific. So gender doesn't really matter. A male employee could be harassed by a female supervisor. In fact, there's a case against Domino's that came out a couple of years ago where a female supervisor made inappropriate physical contact with the male subordinate while whispering, "I love you." She did this on numerous occasions. He resisted. He reported it to management. Management kind of poo-pooed him, said, "Come on, man, you're a man. The heck? What's wrong with you? Can't you handle that?" So eventually he filed an action and won $250,000 in damages, got his job back. I don't know why he wouldn't want to continue to work there. I think the female supervisor was terminated. So that is an example of a male being harassed by a female. Female supervisors, cases are out there where female supervisors have harassed female employees. A recent case where a woman claimed her female supervisor sexually harassed her by touching her making sexually charged remarks about her appearance and clothing and invited her to engage in sexual activity. And the court found sexual harassment, obviously, and awarded significant damages in that case.
Can I interject here for a minute? In addition to these two kinds of stereotyping, you can also have male on male sexual stereotyping. And when you get into the gender stereotyping, it doesn't even necessarily have to be of a sexual nature. It can simply be gender stereotyping. There's a very famous case from Bow Brothers Construction Company where, and I've spoken on this a few times, so if you've been to one of our presentations on this before, you might have heard me talk about it, but a group of iron workers were out on a job site, and one of the iron workers complained that he was being harassed because he had to take wet wipes into the bathroom with him for unknown reasons. And the rest of the iron workers would then make fun of him and say that he's not manly enough and make derogatory comments. That's also a violation of Title VII under gender stereotyping.
Yes. And then, by the way, that reminds me of an oil rig
case. The Sundowner oil rig case,
Sundowner oil rig, where it's the same thing. Except
in that case, well, that was the first case of male on male gender stereotyping, and in that instance, the oil rig worker was severely beaten.
So, as we indicated, just want to confirm again with you, this is part of our teaching process where we go back and touch base on something we mentioned earlier, so it imprints on your brain, that the victim does not need to be the person being harassed. Actually could be the coworker. You can see the young lady there, and she's very uncomfortable. She's cringing while she's witnessing flirting between a supervisor and another employee. She overheard regular sexual banter between coworkers. So the key is that it's just got to be unwelcome conduct. That's the key. And third-party harassment, we touched base on that. And the delivery drivers, for example, delivery drivers making a delivery and are sexually harassed by customers. This is an actual case. The company needs to exercise some control to protect the delivery drivers while they're dealing with client. It's the reverse of you having a customer coming into your place of business and that customer is harassing your people. When your employees go out and they're doing work out in the field, they're entitled to protection as well. And the company can be liable for that. Another example would be a staffing company. An employee was sexually harassed by the host company, the client company. And the employee, the staffing company employee, made a complaint to the host company and then as well to her employer, the staffing company. The host company then said, you know what, we don't want you around. We don't have any work for you here anymore. Magically, by the way, you don't really serve our needs right now. We don't have any work for you. Well, the staffing company at that point in time couldn't find any work for her, and they said, you know, we don't have any work for you now and probably not anything in the foreseeable future. So she filed a lawsuit, was successful, and won a very large award in that case. So you have to protect your employees no matter where they're at, either on premises or off premises. Anything to add to that, Dana?
No.
Sure? Okay.
I'm sure.
Well, now Dana's going to talk to you about training.
My name is Dana Quick. If you do not know me, I handle labor and employment issues here at the firm. I also do commercial litigation and pretty much any commercial matter that comes in the door. We've been talking very recently a lot about sexual harassment because it's been in the news. If you're a member of NORA, you might have seen Mark Barnes and I recently speak on this issue at the monthly meeting. But what I'm going to talk about today is building a proactive corporate culture. And I think that this is really the key when we're talking about sexual harassment, to focus on building this corporate culture. And there's a few ways we're going to do this. We're going to talk about preventing sexual harassment, training with regard to sexual harassment on how not to do it, and investigating allegations of sexual harassment. And it's these three things that work in conjunction to actually build the corporate culture, because if you only have one of them, you might be talking the talk, but you're not walking the walk of being proactive when it comes to sexual harassment.
Sort of like a three-legged stool.
Yeah, you really need to have all three, or you don't have it at all.
Right.
So let's start with preventing sexual harassment, because I think that's where most people are focusing themselves right now, is on how to prevent it, because there's been a lot of news, and I think that people in the C-suite are taking notice, because a lot of big names have fallen recently due to sexual harassment allegations, whether or not they've been founded or not. Allegations are enough right now that careers are gone. People are, ruined, for lack of a better word. So how do you prevent sexual harassment? First, you need to have a clearly written harassment policy. This needs to be in your handbook. It's also a good idea, even if you already have something in your handbook, to maybe write a standalone policy and to pass it around and to have people sign off on it, especially if you're updating that portion of your handbook, but you're not updating anything else right now. So even if you just focus on your sexual harassment policy, get that revised, get it up to date, get people to read it and sign off on it. In that policy, you are going to want to provide some examples of prohibited conduct. Simply stating that we do not tolerate any forms of sexual harassment is not going to be sufficient. You want to put a little bit of meat on the bones, explain to people exactly the kinds of behaviors that are considered to be sexual harassment, such as what Carl just talked about, impeding people's movement, elevator eyes, things that people might be able to explain away in a casual manner. You want to let them know that this is a serious issue and these things are not tolerated. And you'll want to establish clear reporting procedures. And we're going to talk about that in just a minute. But you'll want these reporting procedures to be written, and you'll want them to be circulated to your entire workforce. All right, so let's talk about what your reporting procedures should be. First off, you're going to want to identify for people who they can talk to or who they should report unwanted sexual advances to. And this first one's going to be a little bit of a shocker. The harasser themselves. Not everybody's going to be comfortable talking directly to the person that they feel is harassing them, but you'll want to embolden your employees to the extent that they feel safe and comfortable doing so to work out their own interpersonal issues with other coworkers. And in most instances, in many instances, perhaps just in some, the harasser is unaware that their conduct is unwanted. And so if it's a one-time situation, then the person who was the recipient of the unwanted conduct perhaps simply wants to tell this person, hey, I really didn't like that. I don't like it when people touch me. It's just a thing that I have. It could be as simple as that, and the problem is resolved. Instead of ignoring it and hoping it goes away and then waiting until it becomes a really big issue for the person who is the recipient of this unwanted behavior.
So, in other words, it could be something just as simple as when I put my hand on your shoulder and just say, hey, Dana, I want to look at this real quick. You could just simply say, Carl, that really makes me uncomfortable.
Absolutely.
Okay.
Yeah.
All right.
And when you're talking to the harasser, it's not really so much of a report as simply a conversation.
Right.
Hey, I didn't like that. If you need to go the route of making a report, the direct supervisor is usually somebody that's on list of people that you should talk to. Also, human resources is usually on that list. And in most of the instances of policies that I've seen, that's the beginning and ending of the list, the direct supervisor and human resources. But I would say that you should include on that list any other supervisor that the victim feels comfortable reporting to. Because sometimes it will be the direct supervisor who is the harasser. And sometimes human resources may not be friendly faces for the person who is the recipient of this behavior. And so if there's another supervisor out there that this employee feels comfortable talking to and reporting to, then they should be allowed to talk to that individual.
You recommend putting actual names of people in the reporting procedure, or just any supervisor?
For purposes of establishing a procedure that you're going to circulate to your employees, I would say not to put specific names, because those are going to change.
Right.
Through attrition, through job changes, whatever. Just letting employees know that they can report to any supervisor is sufficient. Okay. And you might need to clarify for your workforce what level of supervisor you would consider to be an appropriate person.
Right. So it may not be a team leader. It needs to be somebody at a higher level.
Right. So if you do have a team leader, perhaps you want to let your team leads know that if somebody reports to them, that they can go with the victim to a supervisor to make that report.
Got it.
And depending on the size of your company, maybe you have a helpline or a hotline or something of that nature where people can call and report. So you'll want to let people know who exactly they should be reporting to, and you'll want to make it as broad as possible so that everybody has somebody that they can report to that they feel comfortable with. Next up is, what is it that you need to make a report? You'll need to get from the victim, and I'm using victim in a very broad sense, whoever it is that's reporting, you'll need to get dates of the alleged behavior, times of the alleged behavior, the name of the person or the persons who were perpetrating the conduct, the name of any witnesses, and a clear description of the events that occurred. And you'll want to get all of this information in writing and signed by the person who's making the report. Sometimes you're going to get some pushback on that, but to the extent that you can, get it in writing. Because what I've found is when an individual makes an oral report to somebody, they are a little freer with what they say. They are a little looser in the tongue, and when asked to write things down, it's not the same story that you were told orally. People are a little more careful with their language when they're writing things down, and they know it can be seen later.
Right.
So to the extent that you can, get it in writing and get it signed by the individual at the time they're making the report.
Does it really matter whether it's in their handwriting that they're writing it out, but just as long as they sign it?
It doesn't. I always feel that it's a little bit stronger if it's in the individual's handwriting or the individual has typed out the statement, as opposed to the report receiver writing it out and then having somebody sign, because that has a little bit more coercion,
right?
A feel of coercion, or
putting words in their mouth.
Yes,
maybe.
Yes. And if the report writer didn't exactly capture the tone, then the whole thing could be a wash.
Right.
Once you have identified who are your report receivers and what they should get, you need to let those people know where the report should go. And if I can give you one example of this, it would be Michigan State University and Dr. Larry Nassar. Because if you listen to any news report about his sentencing procedure, the victims overwhelmingly stated, yes, I did report this to people, but nobody did anything about it. Nobody investigated. And so your report receivers need to know where that report should go. They also should know what actions are expected by management upon receipt of that report. And there should be expected timeframes for taking action. And in this instance, if you're receiving a report, I would hazard a guess that your next step would be to launch an investigation. And so you'll need to be clear about how soon that should happen. And I'll tell you that should be as soon as possible. And I really think that your reporting procedure should have suggested actions based upon the findings of the investigation. This is part of talking the talk of building this culture against sexual harassment. If your potential harassers know exactly what they might be facing, then they might think twice before they tell an off-color joke or jokingly try to block somebody from entering or exiting a room. And it also gives your investigators, which we'll talk about in a minute, guidelines for how they should respond to behavior. Training. Training is one of the trifecta of this corporate culture. When you do training or when you have training done, it really needs to emphasize the basics of respectful and professional behavior towards everyone, from top to bottom, from management to janitor. Everybody needs to have a respectful attitude, respectful behavior, respectful speech. I mean, this is really the basis for harassment claims of any kind, is disrespect. And you'll want to do separate trainings for your hourly employees and for your management. When you talk to hourly employees and management, some things that you'll want to include are examples of appropriate versus inappropriate behavior, what your reporting procedure is that you've already written, and it's pretty imperfect, and now you can just hand it out and have people sign it, any collective bargaining agreement rights or requirements, and let people know that you are serious about investigating every report of sexual harassment. When you talk to management, you should have a conversation with your management team, the people that will be receiving these reports, on how to recognize complaints of sexual harassment. And if you've done any training in the area of FMLA, you know that people aren't going to come to you and say, "Excuse me, Mrs. Supervisor, I believe I have a claim of sexual harassment that I would like to report to you." They're not going to be that direct. So you're going to have to train them on the language to look for, just like you would in an FMLA claim, because people don't come to you and say, "Excuse me, Mr. Supervisor, I believe that I need to exercise my rights under the Family Medical Leave Act to take unpaid time off of work." People just don't do that. You're also going to talk to management about how to take these reports, the information that they should obtain, and how they should speak to the reporting individuals, and what they should do with the reporting individuals after they have taken the report. You'll want to discuss with them anti-retaliation rules, because anybody who's involved in a sexual harassment claim cannot be the subject of retaliation for being a party to that claim, whether they are a reporter or a witness or simply somebody that got drug into it based upon nothing more than somebody naming their name.
It's kind of a big area in that, the retaliation.
Yeah. Retaliation is huge.
Yeah.
And retaliation can take the form not only of termination, but also of not having preferred job assignments that they used to have, or the shifts that they used to work, or demotion of some kind. Also, legal liability, the investigation procedure, and stress that nobody is immune from an investigation, whether it is the CFO or the payroll clerk. Every claim will be investigated. And I see we're running a little short on time, so I'm going to speed through some of this. Investigating claims of sexual harassment. The good news is that if you're well-versed in doing most other forms of investigation in the workplace, that sexual harassment investigations pretty much follow the same procedure. But you're going to want to figure out what that procedure is in advance if you haven't already. So write down your plan of action for when the company receives a sexual harassment report. Identify a pool of potential investigators. And I would really recommend having at least 2 people, depending on the size of your company, at least 2 people investigating these claims. And sitting in on all the interviews, talking to all the witnesses. And to the extent that it's possible, your investigating team should be diverse.
Male and female?
Male and female. Yeah, if possible, I would definitely have somebody of the same gender as the reporter involved in the investigation. And when you have this pool of people identified, provide them with some enhanced training on how to do an investigation if you haven't already. And again, investigate every allegation. I really can't stress that enough. So during the course of your investigation, you're going to interview people. You're going to talk to the accuser, the victim. You're also going to talk to the accused. And I can't tell you how many times I've talked to clients in the middle of an investigation and I said, well, what does the person accused of this have to say? And they tell me that, oh, we didn't talk to them. I said, well, you need to go back and talk to them. But definitely make sure that the accused is one of the witnesses or one of the people that's being interviewed. You also want any witnesses to the behavior, and then any other individual with knowledge. And you're going to know who these people are because every person that comes in and talks to you, you're going to ask them, is there anybody else with information about this that we should talk to? And you're going to ask that from everybody. And then you're going to talk to those people that they name until you close the loop. Until the people that you're talking to all give you the same names and you've already talked to all those people. And you're going to document. You're going to get signed statements from everybody you interview. You're going to have your own interview notes with your own impressions of what people said, how they reacted, things of that nature. You really need to look at whether or not the person accused of the harassment has a history of accusations, whether or not the accusations have been founded. If there is a history of allegations against a specific individual, there is something wrong.
Where there's smoke, there's fire, usually.
Usually. And so you really cannot ignore a history of allegations, and I'll bring you back to Michigan State University and Dr. Larry Nasser. And you'll want to document what other evidence is available. I put recordings that could be surveillance recordings or telephone recordings if you have them, or email servers, time clocks. You're going to best know what evidence is available to either support or refute the allegations that are here. So aside from talking to people, think about what other evidence might be available to make the allegations either more or less likely. And you're going to analyze. And I'm about to give you 2 dirty words: credibility and circumstantial evidence. And credibility has become a dirty word because nobody wants to question the accuser. And that's not what I'm saying here. I'm not saying that you need to doubt what the accuser is saying, especially how it made them feel. If they're telling you that something made them uncomfortable, unless you have evidence to the contrary, go ahead and believe that. But credibility could be something as simple as credibility of the witnesses to the event, whether or not they're friends with the accused, whether they have a potential to get in trouble, for lack of a better word, if the allegations are substantiated. So yes, you absolutely can weigh credibility. That's okay. In circumstantial evidence, I get a lot of my clients who tell me that they can't look at certain things because it's circumstantial. Well, you know, we saw Larry walk into the tool room after Jen, but that's really just circumstantial evidence. It doesn't mean anything. But it does, because circumstantial evidence is only a dirty word when it comes to a criminal proceeding. And you're not conducting a criminal proceeding. You are doing an investigation. And so, yes, as long as you're not only looking at circumstantial evidence, you can absolutely include it in your analysis. And you need to make findings. The first one you need to make is, did the events actually happen? The second one, and this is separate from whether it happened, is whether it was harassment. Because Carl talked about you need two things. It needs to be subjectively unwelcomed and objectively, I can't remember the words Carl used, but there are two standards, subjective and objective, and they have to work together to be harassment. You'll need to make findings about whether or not discipline is appropriate in this case, and what form of discipline. And then if you need to make any other changes, regardless of whether or not discipline is imposed, do you need to make other changes? For example, separating the two individuals or changing shifts. As long as the changes are not seen as punitive in nature to the accuser or to the accused who is found to not have harassed anybody, then the changes may be necessary and appropriate. And this is a step that everybody misses. They forget to follow up. You need to follow up with the person who was accused. Usually, if you're imposing discipline, that's your follow-up. You also need to go back and talk to the victim or the accuser and let them know, we have concluded our investigation. We have either found that there was harassment or found that there was not harassment. You do not have to give them any specifics on any discipline that's imposed, but you do need to go back to the victim and say, we're done with our investigation, and we did make a finding. And then you need to talk to other management on a need-to-know basis. If you have an email blast that goes out to all managers, I would not put your follow-up there. I would let the direct supervisor know, especially if you're imposing discipline or you're making other changes to the job site, what those changes are. But I wouldn't broadcast it, regardless of what the finding is. And this is a standard that you're held to when you're making your investigation. You need to come to reasonable results by using reasonable means. No more, no less. So even if you come to the wrong conclusion, if you investigated and if you did it reasonably and you came to a reasonable result, then by and large, the employer's liability is limited. And lastly, after you conclude your investigation, this is a really good time for you to go back and look at your policies and say, well, this policy worked great and this one didn't work so well. So refine your policies, enhance your procedures, and implement any training for any individuals or groups or departments that you think might be necessary.
Yeah, I have a quick question. When you said, discipline, institute discipline, I know you and I have both seen these policies that say zero tolerance.
Yes.
Sometimes putting the hand on somebody's shoulder is not necessarily pervasive enough and severe enough to warrant termination from employment because you have this inflexible zero tolerance policy. So what I didn't glean from what you were saying that you're promoting zero tolerance.
No, in fact, I would not promote zero tolerance. I think personally that absolute rules make for absolute insanity. So when you're developing your policies, consider having a range of disciplines available depending on the severity of the action and what's warranted in the case. And simply because you have a range doesn't mean that you have to follow it without question. If there's a reason to make the discipline less severe, document that reason in the disciplinary form and in your investigation notes as to why you're making it less severe. If it needs to be more severe, then do the same thing. Anytime that you're going to either go higher or lower, just have it documented why you're doing that.
Or document your thought process, too.
Yes.
Yeah. Okay.
Carrie, do we have any questions?
We do. With supervisors, should we also point out the power issues at play here? And if so, how best to do that?
And this comes to us from Margaret McAllister, who I know very well. Hello, Margaret in Florida. Yeah, when you're doing your supervisor training, you should talk about the power dynamics, because sexual harassment is all about the disparity in power for the most part, whether it's done by a man against a woman or a woman against a man. This is why direct supervisors are often the most commonly
harasser.
Yeah, I'm trying to think of a word that's not pejorative, but yeah, they're most commonly the harasser in these situations.
And because of that, I actually have a question. When you talked about who to report to and the first person being the harasser, I mean, that wouldn't be a mandatory step in the who to report to. That is just your recommendation as an employer.
It's one of the possibilities as a reporter. It does not have to be mandatory. And if you have a mandatory, step 1, step 2, step 3, I would recommend doing away with that and just identifying groups of individuals that you can report to.
So definitely a company needs to have alternate reporting to different individuals for that very reason.
Yes.
Yeah. And the most uncomfortable investigation is when it's the head of the company or the owner of the company.
And in those situations, you might want to consider having somebody outside the company do the investigation, such as your company attorney, or outside counsel, or there are companies that will do this on a contractual basis.
Yeah.
The important thing is finding somebody who understands your corporate values and your corporate structure and doing a investigation that is fulsome.
Wonderful.
You talked about doing the training. How often do you do the training? Just when you get a new hire, or is it something that should be done regularly?
How often do you do the training? Early and often.
As often as necessary. Definitely, from what we've been able to, at least once a year minimum. Twice a year would be good.
Well, thank you so much for joining us today. It was a pleasure talking with you about sexual harassment. And if you have any questions, if you need help in your investigation, you know where to find us.
Great. Thank you very much.